You need to go to court, but there's not enough involved to justify hiring a lawyer. What can you do? I'm Dan Ringer, and we'll talk about unbundling legal services right now on The Law Works.
The following is a production of West Virginia Public Broadcasting.
Closed captioning for The Law Works is made possible by a grant from the West Virginia Bar Foundation to educate the citizens of West Virginia about their rights and responsibilities under the law.
The Law Works is made possible by the generous support of the West Virginia State Bar, the West Virginia Trial Lawyers Association, and by ALPS, providing protection and peace of mind for West Virginia attorneys and their clients since 1988.
You want to represent yourself in court, and you need to fill out a couple of forms you don't understand. No lawyer will help you. What's wrong with this picture? My guests are West Virginia State Bar President Robert Fisher and State Bar Board of Governors member Jay Arsenault. Gentlemen, thank you very much for coming in. Unbundling legal services. What the heck does that mean, and why are we talking about it?
Well, Dan, we're talking about it because several years ago, when I was elected Vice President of the State Bar, I had in the back of my mind that we needed to make sure we had legal services for everybody in the state of West Virginia. I had found during my years as being on the Board of Governors that not everybody could afford an attorney, and especially in divorces. And that seemed to be the area where there was the most trouble. So I started looking and asking about what we could do to serve people especially in the rural areas of West Virginia, people who have limited incomes, middle-class people who just can't afford an attorney. So in looking into this, I found that other states have what's called unbundling, where you unbundle and do part of a legal service.
Typically, an attorney agrees to represent someone, and that's a soup to nuts kind of representation, where you start, they come in, they say, here's my problem, here's what I'm thinking about doing, I need to know what I'm going to do, to the point where the judge signs a final order and the attorney does everything in between. Unbundling is going to be a change from that. Now we should say this is an idea in discussion. It's not going to start tomorrow morning.
That's correct.
But it already happens in some part now. How are you going to know, Jay, what the attorney's going to do?
Well, we think that, as you said, it's part of a process now, and that's one of the things that we're exploring. But in other states, what they're looking to is informed consent. You're going to sit down and you're going to talk between the client and the attorney, and perhaps in a domestic case, you're going to assign responsibilities. The lawyer may be drafting a lot of the pleadings, but as far as gathering the information, the client is going to go out and gather that information, find out what the other spouse is earning, find out what some of the expenses are and things like that that will go into the financial information that needs to be put together. And so there needs to be a discussion between the client and the lawyer and an assignment of responsibilities, and then they're going to be able to unbundle that traditional method of providing legal services.
Well, from the label, unbundling, it would sound as though you might, if you have a form to fill out, you might go to a lawyer and say, I need help filling this form out. But when the form's filled out, you leave, and that's the end of it, at least with the lawyer.
That's great. You know, today, a lawyer is going to be hesitant to help you just fill out a form, because a lawyer knows that he has to provide competent representation, and typically a judge is going to look to that lawyer, and if you're being helped on one form, he's going to be expected to help on all forms and all aspects of this particular case. And so it's an education process for the lawyers, for the clients, and for the judges to get used to this new concept.
You use the phrase informed consent. And whenever I hear informed consent, the hair on the back of my neck stands up, because I personally believe that informed consent is a we call them legal fictions. It just doesn't really exist. I can tell you, I can work with you to try to understand something, but the depth of your understanding when we're done is not going to be very great.
We believe that the forms we're going to put together will be informative, that when the client signs those forms, that they understand that they're hiring that attorney for a very limited purpose, to do one particular part of the legal action that they're involved in. I use, and we go constantly back to the domestic relations court. That seems to be in West Virginia an area with a major problem. It seems, from the data we can find, most divorces are being filed what we call pro se. Pro se means they're representing themselves. Now, pro se does not mean they're poor. It means they just can't afford an attorney, because when they went to see the attorney about representing them in a divorce, they found out it's a $3,000 retainer. They can't afford a $3,000 retainer. So they go to the courthouse and they attempt to walk themselves through the system, and they usually mess it up. So hopefully what this consent form will be is a very detailed contract where when the person signs, they understand, I'm hiring Jay to help me with my quadro. I'm hiring Jay to do my property settlement agreement. And that's all I'm hiring Jay for. Or even better yet, abuse. We see a lot of problems where these people are trying to represent themselves in abuse situations. This will guarantee that you can afford an attorney just to come and help you with the abuse without having to worry about that attorney through the whole entire case.
What you have said raises a number of issues. For example, President Fisher, Rob, used the word quadro. It's an acronym, QDRO. It stands for Qualified Domestic Relations Order. Did you know that? If you didn't, then you can't get divorced, because that's a really important part of a divorce. That's what lawyers are for, is to help you understand that. But where in the world do you get that understanding without talking to a lawyer? And the quadro itself, the order itself, can be hugely complex. It can be an exercise in metaphysics, in statistical analysis, financial calculations that would boggle the mind of most university professors. And you're dealing with generally businesses who are holding retirement accounts, because all of this deals with retirement accounts, that have each of them their own individual rules. Hugely complex area. You're not going to get divorced and have a QDRO or quadro prepared without the help of an expert of some sort.
Well, as Rob said, a lot of the divorces that are going on in this state now are going on pro se. So you wonder what's happening if both sides are pro se. Are they just missing that, and therefore somebody's not getting a part of the pension of their spouse that they would normally be entitled to? We think that if we can go with this unbundling concept, it's win-win for both sides. The client is going to be able to hire someone and perhaps not pay the $3,000 retainer that they would normally have to pay for the entire legal representation, and instead they might be able to pay $1,000 for representation just on the quadro. And the lawyer, rather than being cut out because now the clients are just proceeding pro se, is at least going to win from the business now. He's going to have the $1,000, and he knows that he's just going to have that limited representation on the quadro. And hopefully we think then the client is going to have a better representation and a better outcome than if they had no legal representation at all, which is what's happening in many of the domestic cases today.
We've used the phrase pro se a number of times. Pro se is actually, it's a shortened form of a Latin phrase that means you represent yourself. You proceed without an attorney. You are your own lawyer. And I suppose that begs the old saying that a person who represents himself has a fool for an attorney and a fool for a lawyer. And lawyers have operated as if that's carved in stone. So now we're suggesting something different, that if you can't afford a lawyer, or if you don't want one, you may be able to afford a lawyer, but you may think, I can do this myself, perhaps with some help, that it's okay to represent yourself.
I have no problem with a person representing themselves in a case. The problem I have is if they're representing themselves because they can't afford an attorney. They go to the attorney, they get the $3,000 retainer, they find out it's non-refundable, so they just go and try to play with the system and fill the forms out themselves. I can give you a good example. We're involved in a case in my hometown right now where an older couple in their 60s went to the circuit court, got the forms that are Supreme Court's prescribed, filled them out, apparently filled out the property settlement agreement incorrectly in 1999. Here we are in 2006, and we're back in court representing the ex-husband, and we're fighting like crazy over the property because they didn't fill the forms out right, because they didn't think they could afford an attorney, and they attempted to do it. Now what's happening is we're spending a lot more money hiring us to go back and represent this man. If he would have had somebody looking at his property settlement agreement saying, you got this wrong, you didn't declare all your property, or declared incorrect values or whatever, that they wouldn't be there this many years later, having to fight. 7 years after the divorce, they're now fighting that divorce again. I
handle a fair amount of, we call it family law, divorce law. It includes some other things. I handle a fair amount of family law, and one recent year, I stopped and I looked at what I was doing, and honestly, that year I received more in fees for repairing bad divorces than in getting people new divorces, because you don't know what you have to do, therefore you don't do it, or you do it incorrectly. It may have huge tax consequences if you fill out a form wrong or you don't consider particular issues that would apply to you or to your children or to your spouse. It's mind-boggling. And that is the biggest hesitancy that people have about this, is a lawyer goes to law school for at least 3 years to practice law, and then most people look for lawyers who have some experience at least, so you're looking at somebody who's worked in the field for 5, 10, 20, 30 years. You're counting on that expertise, and when you go in to just have one small portion handled by the lawyer, you give up most all of that. You say, help me with this form. They help you with the form. They do a good job on the form. But when you go to the hearing and the judge looks up and says, have you considered what happens if somebody wants to vacation in Europe with the kids, if you're in a divorce and it's a child custody issue? And you haven't before that point. There you are sitting in the courtroom, you got to answer that. It might be good to have a lawyer with 10 or 15 years of experience with you.
And in a perfect world, everybody would have money and they could be able to afford that. But that's really what we're confronting here in West Virginia, is that this is viewed as an access issue. There are people in this state that just can't afford that $3,000 retainer that any lawyer is going to say, if you want me to handle, as you said, the soup to nuts of the divorce, they're going to want that retainer up front, and then some people just can't afford that. So this is an interim step where we're trying to get people representation that otherwise might not be able to afford that.
We probably ought to caution that we've used the amount $3,000 here a lot. Divorces don't cost $3,000. Divorces cost what they cost. If you've got a complex situation, obviously there'll be more expense. If you've got a simple situation, there will be less expense. But prior to this program, Rob, Jay, and I talked about what typical legal fees in divorces tend to be, and the number 3,000 keeps coming up. And the horror of it is, 15 years ago, divorces were $300. And those fees have gone up and up and up as a result of the amount of time it takes, the complexity of what has to be done, financial disclosure forms, parenting agreements, mediation along the way, parent education. It just takes huge amounts of time, and nowhere is the phrase time is money more true than in a lawyer's office, because that's pretty much what a lawyer sells. That's their product, is their time. Well, you don't have to have an attorney. You can go in pro se by yourself. We're talking about hiring an attorney to do bits and pieces, but not the whole thing, or you can go first class and hire an attorney to do it soup to nuts. Honestly, guys, it sounds like what we're describing is a failure of the American legal system. Are we not serving the people the way we ought to be?
I think we're serving the public. I agree with you. Our obligation is that we have a duty to the public, we have a duty to the judicial system, and we have a duty to our fellow attorneys. And in doing those duties in the administration of justice, the problem is an attorney has to be paid for their services. And the way the system is set up now is once you're in the case, you're in the case for the whole 9 yards. From the minute that you put your name on the pleadings, you're in it till the end. And that's the part, and that's the reason that the lawyers will not take these cases. They want to be paid up front in case there's a problem later on in getting paid, because usually money becomes an issue in divorces, and almost every divorce money becomes an issue. So it's not that it's a failure of the system, it's a failure of the judicial system not to allow a lawyer to come in on a limited basis, but forces the lawyer to take the case all the way to the end when the lawyer really doesn't want to.
Or the client.
And the client doesn't want him to.
Yeah. Aren't we already doing at least some of this? In my practice, it is not uncommon for somebody to say, I would like to come to see you to talk about a problem I'm having and to get your insight into the problem. And I think most attorneys under those circumstances say, okay, fine, come on in. I'm going to charge you for this consultation. It's not a free initial consultation because you're not thinking about hiring me. You want some advice, come on in, let's talk about advice. It may be how to structure a will, whether you need a new will, whether you need a divorce. You know, sometimes lawyers will tell you when you come in to talk about a divorce that really that's not the solution to your problems, or you ought to explore other possible solutions. You talk about wanting to set up a business. A lawyer will arrange a meeting where you can talk about the form of the business. Those are, in a sense, unbundled services, aren't they?
I think they are. And I think that often there is this consultation aspect where we really get into the problem is where you want to be involved in the litigation process. And that's really now the model is soup to nuts. You can't appear in court except for in very limited circumstances, and a lot of times it'll depend on the judge. But in many circuit courts within West Virginia, if you appear for one purpose, then the judge is going to say to you, all right, now you're in this case, and I'm not going to let you out of this case until the case is over. And so really, that's where we're talking about, and that's why we're focused on domestic, because that's a good example of where you can get into a domestic matter, and it can look like it's going to be a very simple matter when you get into it. But as it progresses, there may be some kind of child custody dispute or some unforeseen event all of a sudden that now where we're talking about time is money, all of a sudden you're going to spend a tremendous amount of time that nobody foresaw. And an attorney is looking at that, and they're building that into their fee up front. That's why they're wanting the money up front, because they're saying there may be something that's going to go wrong here, and I want it all up front. And so it's really in the litigation cases. I think you still are going to see cases where it might be somebody that's going to come in and consult about a matter, might come in and consult about a quadro, might come in and consult about a property settlement agreement, but no lawyer is going to sign anything or help you really fill out that form and let their name be on it, because then they know that the judge is going to look to them, oh, who prepared this? Oh, Rob Fisher prepared this? Well, I want to see him next time we have a court hearing. Tell him I want him to come in and talk about why he filled out this the way he did. And that's what the concern is. And by unbundling and having the education process to let the judges and the lawyers and the clients know that this is now going to be an acceptable thing in the state of West Virginia is what we're trying to achieve.
Let me add one thing about that. In your first example, where you talk about wills or a deed or those kind of limited things, that's transactional law. Transactional law is historically you do an item, you're done with the item, the client leaves, and that client's not your client anymore. Litigation, what Jay was talking about, is the other side. We have transactional law, we have litigation law. The litigation area is the forum where you're married to the case from the beginning to the end. And it's in every litigation case, every kind of litigation. But we have found through the research, that Jay can tell you all about this research, that domestic relations and bankruptcy seem to be two areas where it will work very well. And we know, I will tell you that the committee, the Family Law Committee of the State Bar has endorsed this concept, and that Judge Pearson of the Southern District Bankruptcy Judge has also endorsed it and looking into it as a concept that he would like to see what could happen in bankruptcy court.
Why is bankruptcy amenable to this transactional practice?
Once again, there's forms that you can obtain at very little cost if you can afford a filing fee. And before I forget, if you file a divorce, and you would know this better than me, if you are an indigent, you don't even have to pay a filing fee.
That's correct.
So that they can literally do their whole divorce at no cost whatsoever. I don't know about bankruptcy, if that is the way the rule is there or not, but nevertheless, they can get the forms and fill it out themselves, and then they go into that mess and they start getting there's lawyers on the other side representing banks and credit card companies and whoever they got their car loan through. And they're trying to represent themselves against these creditors' attorneys. Usually those attorneys are from big firms too. And they're overwhelmed. And at this point, they could have a lawyer help them fill out the bankruptcy petition, make sure they get the right thing, right debts in the right categories and so forth,
well,
without being involved in the whole case.
Talking to the other side's lawyer is something that would intimidate me as a consumer of law, as a prospective client, as a pro se, go it on your own litigant. How in the world am I going to have a fair discussion with a high school education calling Jay Arsenault or Rob Fisher or even Dan Ringer at the other end of the spectrum and expect to be able to convince him or extract some compromise or some accommodation from him? Because everybody knows that lawyers are going to twist your words and distort reality.
It's a little unfair.
Well, I've been accused of doing that. I kind of take pride in it. Well, I will tell you, because I've had to litigate a number of cases with pro se litigants, and we have a client in West Virginia. We represent them throughout the state in trip and fall cases, and I find that it's not uncommon in circuit court for people to file their cases pro se in circuit court over a simple trip and fall. And you know, when I have a pro se person on the other side, I know the judge is going to bend over backwards to be fair to them, and I know that I have to bend over backwards to be fair to them. And I could say with all honesty that I don't believe that I have ever tried to take advantage of somebody because they're pro se, because I know the judge is not going to allow me to do that.
Well, if the judge becomes aware of it, I cannot tell you how many times I have had people call me on the phone and say, I fell down in Super Wall Center or something. There was a can of Coke on the floor and I slipped and I fell in and I broke my ankle. And they came over and they said, we'll take care of the medical bills. You'll be okay, just going up to the hospital. He said, I went up to the hospital and I called them back and they said, who are you and what are you talking about? And I have to explain to them then that the only reason that was said to them was to get them out of the store. We don't want to hear from you anymore. And that's just dealing with the store manager. Now the store manager or the company brings in their lawyer who again says, well, who are you and what are you talking about? We have no report of this. There was no accident investigation by any kind of police agency, because they don't do that sort of thing. What are you going to do? Have your lawyer call us. How much are your medical bills? $3,000? We're not going to talk to you. You can't hire a lawyer for $3,000. The people are hopelessly without a remedy. So you go to a lawyer and say, what can I do? And maybe the lawyer can help you without being involved in it, soup to nuts.
True. True. I don't see unbundling as involved in that situation you just gave us. I'm not sure we have an answer for that one yet. Do you see unbundling working in his fact situation?
Well, you could have unbundling. You could have a pro se person who might now just file a simple complaint, and I've had handwritten complaints filed in the circuit courts of the state of West Virginia. A person that was pro se in a trip and fall case could go to a lawyer, and the lawyer said, well, you know, I'm not going to help you until the day of trial. But here, I'm going to draft your complaint. I'm going to give you some forms for discovery, and you're going to finish them up and figure out what you're going to ask for. And you're going to come back with the discovery after it's done, and then we'll sit down and talk about it, and I'll go try the case. And you could have an arrangement like that, and as long as there was a discussion between them and they knew what the pros and cons of that was going to be, then I think you could proceed along those lines, and it might make it possible for a lawyer to represent somebody that only had $3,000 in damages that they might not otherwise do.
I have come to believe in recent years that small cases just don't exist on the legal radar anymore. Early in the show, I suggested that perhaps this was evidence of a failure of the American legal system. I want to suggest something else to you. You're going to say this is self-serving. He's saying this because he's a lawyer, and you may be right. It's not a failure of the American legal system. It's a recognition by the American legal system that there are problems in the system, even if it is 225 years old, or many more hundreds than that if you look back to our roots in this system in Western civilization. This is a recognition of a problem, and at least a couple of people are trying to do something about it. And for that, we thank you. Jay Arsenault from the Board of Governors of the West Virginia State Bar, Rob Fisher, President of the West Virginia State Bar. Gentlemen, thank you very much for coming in and being with us this evening.
Thank you.
Thank you.
Thank you also for being with us. On behalf of the LawWorks, I'm Dan Ringer. Good evening. If you want to know if you need a lawyer, you can discuss your problem with a lawyer by calling the West Virginia State Bar Helpline, toll-free, Tuesday evenings from 6 to 8 at 1-800-642-3617. On the LawWorks webpage at thelawworks.org, you'll find a complete listing of all the LawWorks show topics, information on how to obtain copies of the programs, and additional information about this show's topic. You'll also find a list of legal resources that can help you answer your legal questions. If you would like to suggest a topic for a future The LawWorks show, you can send us email to thelawworks@adelphia.net.
The LawWorks is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, the West Virginia Trial Lawyers Association, and the West Virginia University College of Law. The LawWorks is made possible by the generous support of the West Virginia State Bar, the West Virginia Trial Lawyers Association, and by ALPS, providing protection and peace of mind for West Virginia attorneys and their clients since 1988.
Closed captioning for the LawWorks is made possible by a grant from the West Virginia Bar Foundation to educate the citizens of West Virginia about their rights and responsibilities under the law.
This has been a production of West Virginia Public Broadcasting.